Добрый день, дорогие друзья. Сегодня
Good afternoon or good morning, dear friends. So this is the third day of our conference, and I'm delighted to welcome you in our Moscow studio today. So we'll be talking about patent law. This is one of the most complex topic to be considered because it covers many various cases from administrative law and court-based proceedings. So my name is Dmitry Borovsky, patent attorney and head of the legal department at the Patent Volga Service, LLC, and also vice president of St. Petersburg Association of Patent Attorneys. And we have a partner for our session that is Hogan Lovells. That's an international company, and it is with great pleasure that I'm giving the floor to my colleague, Aleksey Zalesov. So he'll be speaking about the assessment of the inventive step of the object and validity disputes and its relationship to the scope of protection of the invention. Dmitry, thank you very much for the introduction, and also thank you very much for the opportunity to make my speech during this conference. So I would like to thank the organizers because I see it as a unique opportunity at these times of coronavirus that you can meet your colleagues and you can share your views. You don't feel that much isolated. So we'll be talking about patent law. And that patent law is a very exciting element of IP law at large. So we are just taking the issues that are at crossroads, and these are the neighboring uh, bit issues between various fields of litigation and consideration. So there was one issue in particular about monopoly that can be extended to patent and whether these can be seen as a monopoly right when we're talking about patent. So yes, my affirmative. So patent is a form of monopoly, and this is a objective right is a monopoly that has been held by the patentee, the patent owner, that I stress the patent owner, not the inventor. So sadly, our legislation is a bit confusing on that part because the legislation says that the right belongs to the author because it's not the author that actually owns the patent, but the patent, because if the author receives the patent, then the author turns into the patent owner, so the person that owns the right, but in the capacity of the patent owner rather than the author of the patent. So monopoly, many people try not to talk about it because of the negative connotation in terms of high price or lack of fairness, because the society wants the Federal Monopoly Service, Anti-Monopoly Service, to do something about monopoly, to cope with it. And we are looking at the patent. The patent is the way to legalize monopoly once this monopoly is legitimate and fair, and this is beneficial to the society. So the reason why, because we don't lose anything. That remember that classic type of monopoly, then you would have three production sites producing some goods to the market, and then there would be just one competitor entering the market and buying all the three assets. One factory was closed, and then we saw the reduction of the supply in the market, and then obviously two operating sites instead of one. So that wasn't a good thing to the society. But now we're talking about two different things. A monopoly is the right that will be acquired for something that just did not exist previously. So with my examples and those production sites that they were in place, but now we are talking about the patents and this first distinctive feature. So the monopoly will be handed to, with respect to something that wasn't there, did not exist. And secondly, it was something that wasn't obvious to the society. So the society, the community themselves, they couldn't create it themselves, even if they wouldn't have it's engaged a specialist, because the specialists or the experts, they couldn't come up with the same brilliant idea. So we know that this monopoly is given as a right. So in order to get the discovery about or disclosure about this technical solution that was not obvious to the community. So we can get this 20-year monopoly for pharmaceutical products, for instance, and then after this passage of time, so it will pass into the public domain. So over these are non-obvious technical solutions, and then the community, the society would be using to the results just without paying for them for a certain period of time, and then it would receive it into this public domain. So, and we looking at the monopoly price, even if it's a high price. So for pharmaceuticals, then this is a good thing, provided that it has been legalized and it has been lawfully substantiated, that we provide monopoly on something that is non-obvious, and this non-obvious is not something that lots of polymers and know that there are experts and they can get the same result. No, that's the substance that is entirely new. No one ever investigated it before. This is this first type of molecule with some research properties, and then you get it, and then you go through clinical trials, which is a very hard thing to do just for the company that starts the exercise. So they have every right to get this high price, to derive their profit and to cover their expenses and to produce in the future other types of I emphasize non-obvious pharmaceuticals that the society, the community themselves wouldn't be able to come up with by themselves. So we are talking about, yes, the monopoly is there, and this legal type of monopoly, the one that is legitimate and substantiated. So this is a beneficial to the society, and this needs to be protected. But now let's look at this protection issue, because on the one hand, we need to protect the things that are legal. On the other hand, we need to counteract the monopoly that is illegal or illegitimate. So we don't need any committees, so we don't need and even federal agencies to help us. That just the patent owner, because the patent owner, once he's holding on to his patent, or this kind of activity will be considered as legitimate. And then we just, that the federal agency was saying that, all right, we made the market research and now we see that you had this dominant position in the market. So, but that's reasonable, because if I held my dominant position in the market because of the patent scope, then that's fine. But if I go beyond the patent and trying to regulate relationships between the stakeholders, like I'm going to give the rights to this party, but I will not be giving them to the others. So this is a kind of abuse. So then the monopoly regulation should be there to make sure that all the relationships are according to the rules, but it shouldn't be made as part of this classic patent law and the right when you have this monopoly and there's one patent owner that will be producing these protected goods. And moving on to the subject matter of my presentations regarding patent validity disputes, and also in relationship to the scope of protection, and the single criterion that said that it was non-obvious and the society communities themselves, they couldn't achieve that result. So, and I'm just referring to this key criterion, that is the inventive step. So that's subjective for the patent right. This is the right that is enshrined in the law. So it is legitimate because it meets all the requirements that have been set by the law, so including the usage and the discovery of information regarding the invention. So there is this requirement of a sufficient disclosure, and it is through the prism of this requirement that we analyze the patentability of objects. And today we take the inventive step as our key direction for discussion. Right. So inventive step. That's by way of introduction. I'd like to say that and this applies both to domestic legislation and also international practices. So we look at the inventive step as formulated, that this is a solution that is non-obvious from the state of art to the specialist. Some would call it like average specialist. So this wording is vague, and that is a bit diluted because you can think about the specialist, so that can be a kind of legal fiction. And we have seen lots of theses, works on this subject, and it doesn't help us to differentiate between those inventions that lacking this inventive step and those that do have inventive step in them. And it's a shame because if we just try and take a step back to the Soviet past, because we do remember that there used to be this examination procedure for Soviet authors, and by the way, patents were issued for international authors. So there was one criteria to distinguish between the two for the purposes of prior art. So there was the novelty plus substantial differences, and those substantial differences later were replaced with the inventive step. And to me, there's the substantial difference. I mean, they are uh, 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 there can be interpreted in a very simple way. So it should be novel, and it should be different from all analogous technical solution. It also should be substantially different. So the adjective emphasizing that we're not talking about some improvement that can be achieved by any person that has some technical background. So I really saw that this applied nature of substantial differences in the notion itself as it were applied back in the Soviet times. So currently, so we look at the object and we analyze it, be it for the purposes of opposition or the claiming that it will be the civil code provisions that apply. But when you take this obvious parameter, it's not very certain, because it can be obvious to one person and it will not be obvious to another person. Therefore, in addition to the civil code, we need also to rely on the regulations, because regulations can put forward certain examples where we see prototypes, we see distinctive features, and also an explanation as to what the technical result is all about. Plus, we can see the prior art and also the relationship with the technical result. So this simplifies the task of the committee, because based on all of this, now the committee or the experts can make a decision with respect to the absence or presence of inventive step. Right, but in that case, so we'll be talking about the correctness of assessment. Say that the patent was issued in 19 years ago, and then someone would say that wasn't exactly the thing that I meant 19 years ago. It's just not that I want to improve the dissolution of the substance. What I meant was just to go through this technical problem and to get the desired effect by the process involved. Just we, when we look at patent applications, not all of them would be featuring the definition of the technical results like quote, unquote, plus providing the substantiation of it. So we know that these applications are rare. So it's a good thing when an application would include the word technical results, and this is other applications that we receive from abroad. So I'm talking about the applied nature, so of analysis. So it's complex, and it's difficult to do because we don't have any concrete data and information. Plus, we'll be talking about this abstract requirement, our legislation that will be put into concrete terms by the experts and also by our colleagues from the patent chamber. So when hearing the case on the merits, so they will be just making it concrete based on those data that are available to the authorities, and they will be looking also at these similarities from a prior art, and then our colleagues from patent chambers, also the patent dispute division. So they will be looking through the positions that are submitted by the parties. So and yet, and again, we see that the presence of inventive step, that as an abstract term that is that is formulated an abstract word. So now it becomes more concrete. So as part of the expert analysis of the inventive step in specific proceedings, and then one expert would say, so for instance, yes, so I can demonstrate the absence, or on the contrary, the presence of inventive step, because we can clearly establish the link between the solution and the technical result. So at all times, we'll be seeing it as a legal fact, and it just being overlooked. And as a result, we see once the patent is received, so it is assumed to be in compliance with this inventive step requirement. But when we take a closer look at the application, so this is taken as a matter of fact, and the fact that is demonstrated by the patent agency, the domestic authority, and also the European Patent Agency, and by the applicant himself or herself as agreeing to the criterion of inventive step. So this is the legal fact. So these are the references from prior art, and they are substantially different from the one that is claimed by the applicant. So the expert concurred with the view, and then the patent validity division or chamber also upheld the decision. And then we see that this legal fact, but also as a result of a product of actions that have been made by the expert. So the expert just evidencing it, so that the applicant stance that has been corroborated by the patent itself. So that's a simple fact, but unfortunately, it's not thoroughly analyzed in our practice. So, and this needs to be corrected. So the reason why, because we know that the patent disputes and validity disputes and infringement disputes, there's a two distinct category of cases. We know that there are patentability disputes and the appeal is there, so the decision can be appealed to the IP court once it's rendered as a first instance by the patent agency. However, we don't see the determination of the scope of patent monopoly, and therefore we cannot, and then we take this fact whether the object is patentable or not, also as a separate proceeding. So in that case, we see that a patent owner may say, like, just hold on, because so it is different, it is like substantially different because the inventive step is there. And alternatively, probably we may have right that there is an object because it is similar or close to a prior art, and then at the case that the patent owner should just demonstrate that there is no substantial difference, and probably if there is a slight difference, then that would be equivalent to another element from his or her invention. So it just going in the opposite direction to make an argument in the case. So, and I believe so that our views, the views from our expert community and from the IP court will be on the same page, that just this is a situation where we see that the patent owner just demonstrating the scope of the patent as something that is related to either the state of art in terms of novelty, or probably the state of art with some minor modifications. So this means that the well-known analogs then indicate the absence of an inventive step with the invention that has been already patented. So once we receive the patent, and then if we go through the position period, then there is no way that for inconsistency. That is supported by the doctrine of estoppel, and the IP court has emphasized the importance of it. And I know we have seen the resolution from the higher commercial court, and so they didn't specifically mention this doctrine of estoppel, but they indicated that there was no room for inconsistency in the conduct by the patent owner. So this can be now taken as a well-established principle in patent proceedings. So just taking the more practical view of estoppel and its role, and also in assessing the inventive step, my conclusion would be it's not that the situation that we can see this infringement, for instance. So I had a case where the patent owner just wanted to prove that they excluded the strong spirits from the formula, and then that was his invention. And there was another claim for 70% content and a 0.70 content of strong spirits, and that was inconsistent because first he claimed that there was something new, there was a novelty, and then he referred to a very specific product from this just the state of art that was infringing his patent claims. It's just the principle of the infringement that also will invoke the theory of equivalent. It's not only the presence of all the elements in the suspected or the alleged product, but also those elements that are equivalent. So the equivalency theory and should be just limited to the practical application whenever we have this distinctive feature for the patent invention as opposed to the state of the art. So this cannot be seen as the equivalent one, because if this is the sole feature, just the only one that distinguishes our invention from the prototype, and then uh, supported by the patent, and then we see that the product enters the market with just this only element, but presented in a different form, such a simply different form. And I remember that the patent owner who claimed that he added that element that was not obvious to the specialist, and then came another person just with another brilliant idea that was simply equivalent. So, and that my unique element or my unique feature was implemented in the way I did it. And yes, there were alternatives, just I didn't think about it at this stage of replication. So that's like the kind of reflection from the part of the patent owner. So he didn't say that this could be done and could have been done differently. And we know that there are other people, so they come up with replacements, they come up with other ideas, and this is a mere abuse of the patent, and this means going beyond the boundaries, the scope of the patent. So, and once this we reach beyond the scope, so that means that we are outside the boundaries of the monopoly, that equals to illegal or illegitimate activity. And to conclude my speech, I would like to say that this goes without saying that all the case file for the application and also responses that are prepared by the applicant and explaining why his brilliant idea is different from the state of the art, and just the case file that was taken by the Russian patent agency, and again the applicant explained it in greater detail. So all these specific features of the patent and the two files, though they should be admissible. So in the infringement case, so when we see that the patent owner takes a contrary stance, saying that when he filed the application, actually he meant a different thing, and now his views are changed. So this should be taken as an argument in the first court instance proceedings and also on appeal. So, and by this highest court on intellectual property law in all the cases that concerning infringement of the patent rights, because as I said, that means the abuse of monopoly and being at the examination stage or at the stage of opposition. So we'll be looking at the scope of legal protection, including infringement claims. So uh, I'm strongly in favor of bringing the two proceedings into one process, just like infringement cases can be included in the jurisdiction of the IP court, and that will help us to merge the proceedings, right? But if even we do have this bifurcation, so bifurcation is there. So for then, I believe this kind of evidence should be taken and closely scrutinized by judges, so that our judges, our courts, just they shouldn't just help patent owners to broaden the scope of their patent, because once you receive your patent, then the scope of protection is determined and you shouldn't try and go beyond it. So thank you very much for listening, and I'll be happy to take your questions from the audience and from moderator as well. First of all, we now see greetings from different cities, Saratov, Tomsk, and Omsk, many other cities that are online. And these are the first questions that we have received. And let me remind you, you can use our chat box to put your questions in. So it's Vyacheslav from Antona from Tomsk. It's about this drastic differences between Russia and the United States and the European Union. So thank you very much for your question. So this the key difference is interpretation. So I'll be talking about the European Patent Agency, not the European Union, because European Patent Agency is not the EU body, but it's the body that is regulated by its own convention, and there are other countries, non-EU countries, that are parties to this convention. So yes, there's the convention-based approach that includes this non-obvious to the specialist clause. However, whenever they deal with such cases and they have this more practical approach as problem solution approach, and the experts will be looking into the task and seeing how this can be addressed from a practical perspective by a specialist. So for European applications, it's not the technical result, but the task setting. So the way that you formulate your task in order to get the solution through your invention or technical invention that enables you to solve a specific task. So this is kind of more subject matter oriented proceedings, and the expert need to provide evidence either from the textbook or literature just to substantiate and to demonstrate the state of the art. In the United States, you have this non-obviousness, so, and which needs no further interpretation to this effect. And it's the Supreme Court of the United States and its rulings that have prevalence in all the cases, because from time to time, the US Supreme Court would be dealing with the patent cases and building up the case law. So these are the recommendations. So based on the EU, based on the Supreme Court decisions, because we do know that in the United States, the case law is a source of law in that jurisdiction. But yes, there is a certain distinction. Take estoppel, the doctrine of estoppel is sacred in the United States. So its counterclaims are very frequent. When the counterclaims opposing to the validity of the patents, and then US patent attorneys, they will be scrutinizing each and every detail of the application, while in Russia, so that's like we may be arguing that it's non-obvious, so it's substantially different. And then we'll be just looking at the case of equivalence. So this is not the case in the United States, because you are going to have the jury. And I mean, I wouldn't imagine, I mean, I wouldn't even think of a situation where the patent attorney would be explaining the brilliance of an invention and then just saying, just forget about it. Now I have another idea, so it's not that brilliant at all. So this is not the case in the United States, and so therefore this is this distinction. So in the cases, so you have this genius, the stroke of genius. It's yet another story for the US jurisdiction. It goes beyond the novelty. So you need to have that flash of genius, like for the invention that is not even available to average to people on average. So that's about the legislative approaches. To the invention that needs to be substantially different. So we know that the devil is in the detail. However, there is a strive for standardization, a uniformity of approach. So in the community, there is a good understanding, so that they can provide monopoly for certain benefits. And I'd like to agree that there are no some drastic differences, but there's lots of nuances and subtleties in the regulation. So the flash of stroke, the one you mentioned, and that Tatiana would like to take on this point. So don't you think it is reasonable just to step away from this technical creation, and then the inventive step can be replaced with the utility? So just going towards the economic side, because we do have copyright for this useless kind of creation. No, this is not the thing that you want to do. Otherwise, because you'll be breaking the principles of the patent system. It just, if you receive the monopolies, the monopoly is given on something that the community themselves just couldn't create it. They couldn't do it. Then many things have been already uh, implemented, and this kind of utilitarian nature for the patent. And as a matter of fact, so we have this inventive step, and as a criterion, or that doesn't work as a filter function in terms of like genius as opposed to new, useful or technical models. No, I'd say that this is the key thing. And the next disclosure. So you need to disclose all the information, not just explain that I want to create a device that will fly onto the Mars planet. No, that's not just describing the task and then enumerating all the elements of it. No, you need to explain the process of invention. You'll be disclosing it as part of your monopoly right, and also disclosing that non-obvious element. Yeah, I agree. But when we're talking about this utility or element to usefulness, I remember that back in the Soviet Union, we had efficiency as a separate criterion for the economic assessment, but still it's there. So Anastasia Brogina. So is there any sense? I mean, when a case is brought before the patent chamber, and is there any sense to involve an expert on the application? So have you ever engaged as experts? So I take that these are experts from the filing stage. Yes, but let me remind you that those experts from the examination period, from the examination stage, they are there. I mean, in most of the cases, it would be those experts that considered the application in the first place during the examination, but not necessarily those people, but the experts from the same panel, because if a patent was received 20 years ago, probably they changed their staff and now the different people doing the examination exercise. Nevertheless, so these people will be there. And so this communication between the expert and the applicant is very important, I mean, to determine the scope of the patent. So I'm for the records. So let's put it on the record, because it will be very hard to remember what happened 20 years ago. And by the way, so this person that files an opposition should be granted an access to all the requests that were sent by the examination panel, and also all the responses that were forwarded by the applicant. There's lots of uncertainty because the rules were changed at certain point in time back in the past, and then the rejections were filed. So that these are the case files. So you mentioned the European jurisdiction. So you can go to the website of the European Patent Agency, and to find all case files, you get all the materials stored in there in electronic format. And unfortunately, this is not the way that we operate in Russia, because this kind of data is not readily available electronically and on the website. So thank you so much for your excellent presentation. Now we have participants from Tumen. So now I would like to ask a question from my side. So would you give us a couple of practical recommendations as to whenever we have the defendant in the patent infringement case? So what's the defendant, what kind of life hikes our defendant can use? So the first thing would be just to check it against the doctrine of estoppel. This is good. What else? So when I started to taking up patent cases, which was a long time ago, and I learned from other jurisdictions. So I talked to my colleagues from the United States and Europe, and that just was by way of the formal talk that they would give that kind of advice. So just there are no valid patents, just there are patents that have not been investigated like closely yet. So what that means is that most of patents are granted with certain defects, and some of those defects may constitute grounds for invalidation. Yes, that takes a long period of time, and also huge efforts to go through the case files and looking at all the applications and evidence. But believe me, you can uncover some surprising facts. So once you receive this application or opposition, then you need to go through the validity of the patent, and then you need to file your opposition, but not to try and protract the proceeding, because some people would be using as tactics in the litigation. So probably they would achieve a stay. So if you start an administrative vein, then you can move on to the court-based consideration. What I'm saying, it just is valid, and the evidence, the base, so these can be to a lesser or to a greater extent. So I suggest you scrutinize all the files, and then you bring them before the court that dealing with the infringement case. So, and in that case, you would prevent any broad interpretation on the part of the patent owner, unless you copy it entirely and you enter your product in the market. If it's a pharmaceutical product, just copy it from another one. But if it is your own invention, which is equivalent, then you can do and make your stance to defend your product. So thank you so much. So our questions have been exhausted, and I do hope that we will be able to live up to the date and see the situation that we can see in Germany today. So we see that any infringement claim would trigger the validity proceeding. So, and then we see that there will be less abuse for patent rights in our jurisdiction as well.